Okay, well, welcome everyone. We'll go ahead and get started. A lot of folks are joining right now. So we'll give everyone a minute to get in the room, test your audio, um, and I'll go ahead and share our presentation. Okay, so our presentation is being shared. We're going to go ahead and give folks just another minute or so to jump on the call, and then we'll get going in about 1 minute. Okay, so let's go ahead and get started. Welcome everyone to our training on respectful workplace for managers. If you are not a manager, you may want to join the respectful workplace training for employees later this week. Um, Participants will be muted during the call, just in the interest of keeping background noise to a minimum. And I will go ahead and do a couple housekeeping items before we get going. We will have about an hour presentation today, give or take. We do have several opportunities for you to interact. I've got some polls, some little pop quizzes that we'll do during this session. So please do participate in those polls. All of the questions that you are asked today, your responses are completely anonymous. I can't see who answers what, so please do participate. At the end of our session today, we will have some time for a Q&A session, hopefully. If you have any questions that you're coming to our presentation today with, you can go ahead and put those in the Q&A. The Q&A button is in the middle of your Zoom toolbar, and it says Q&A, pretty easy to find. Your questions there are also anonymous, so I can't see who asks the question. If somebody asks a question that you think is great, you'd like to know the answer to as well, go ahead and upvote that question, and that'll move it towards the top of the list for us. During the session, if you have anything else you'd like to share, please use the chat tool. Now, in the Zoom webinar, your toolbar might look a little different than a regular Zoom call. So you may have to hit the little more icon on your Zoom toolbar to find the chat function. Okay, well, I'm going to go ahead and direct your attention to our presentation, and we'll get the show on the road. So for those of you that have been in a training with me before, I'm Liza Town. I am an HR consultant in the Omaha, Nebraska area. So a few hours away from most of you in the Denver area, but I do get around there quite frequently. And it's really great to see some familiar names on our presentation today. So for those of you that I haven't met before, welcome. Thank you for joining us. So today we'll be talking about building a respectful workplace. We want to talk about first, why are we here? Why is this topic so important, right? Next, we'll walk through what you need to know and how you can help create a positive working environment. So let's start with the easy stuff. Why are we here? So we want to create an environment where everyone feels welcomed and respected. So creating a respectful work environment free from harassment and discrimination is critical to everyone's continued path to success, right? So employees thrive when you're empowered to experiment, learn, be curious, and be comfortable enough to fail every once in a while. That means that we need to create a work environment that is comfortable, safe, respectful, and one that appreciates new ideas and diversity in thought. So therefore, it's our goal today to talk about how we can continue to create a work environment that enhances your employee experience. So, research shows that when harassment and discrimination are present in the workplace, employees don't feel safe or comfortable being their most authentic self at work, right? So, research shows that company performance suffers, including lowering morale. It negatively impacts the employee experience, increases employee absenteeism, and so much more. So here's what we would like to accomplish together today. We want to talk about promoting positive and productive working relationships. We want to give you the tools that you need to thrive and perform your best every day. Empower you to create a work environment that's comfortable and encourages creativity, innovation, diversity, and thought. And we want to identify and eliminate any harassing, discriminating, and bullying behaviors that interfere with your mission, vision, values, right? So here's some things we're not here to do. We don't want to create any unnecessary rules or policies. That's not what we're here to do today. We don't want you to leave here feeling nervous or uncomfortable about interacting with your coworkers. We don't want to prevent you from being your full self every day at work, right? Okay, so let's move into the what you will learn today. Um, Federal law that defines harassment and discrimination is known as Title VII. We're going to talk about what it is and what it isn't. We'll review policy. We'll talk about how you can respond to unwelcome behaviors and how each of you can continue to contribute to a positive work environment. We'll also talk about your role as a manager and your duty to act, right? And we'll get into that towards the end of the session here. But we all do, as managers, have a duty to act and respond when we see discriminating or harassing behaviors happening. So let's jump right into Title VII. So, what is Title VII? So, back in 1964, our country was in a very different state, right? We're in the midst of civil rights movement where segregation was still really prominent. At that time, the federal law was put into place to bring equality into the workplace. This was really new territory, right? So, specifically, Title VII prohibits harassment and discrimination against individuals on the basis of a protected class. So, we'll review the protected classes further. It also prohibits sexual harassment and defines it in two forms: so, quid pro quo or a hostile work environment, both of which we'll review in more detail. Lastly, it prohibits retaliation against an individual for engaging in a protected activity, such as reporting such behaviors. So, Title VII applies to employers who have 15 or more employees. So, there's also, since Title VII was enacted, right, a long time ago, there have been recent added protections for LGBTQ employees. So, the Supreme Court in June issued a ruling that makes equal treatment for LGBTQ employees a federal mandate. So, we'll talk a little bit more about how the new mandate um, interacts with the laws that are already in place. So, under Title VII, on the left-hand column on your screen here, you'll see protected classes under federal equal employment opportunity law. So, to understand the law, it's important to understand what's defined as a protected class, right? So, under the federal law, race, color, national origin, religion, sex, disability, age, citizenship status, and genetic information are protected. Now, along with the Supreme Court ruling, sex, the definition of sex has expanded, right? And it includes pregnancy, childbirth, related medical conditions, sexual orientation, gender identity, and also transgender status. So, Colorado state anti-discrimination laws go a little bit further. So, on the right, you'll see they've added several additional protected categories. Um, Sexual orientation was added in Colorado much before it was added on the federal side. AIDS and HIV status, mental illness, marital status or civil union with a coworker. Now, there are some exceptions there. Sharing of wage information, and then there are also some new protections under the Healthy Family Work Act. And we'll talk about those in the employment law basics session that's coming up later this week. Okay. So what is discrimination? All of those protected classes are, protected from discrimination, right? But what's our definition, right? So discrimination is defined as treating people differently based on somebody's protected class, right? Now, there are several signs of discrimination, and they start with the more overt, the things that are kind of right in your face, right? And they can range from overt to really, really subtle. So, overt discrimination could be discriminatory or biased statements about a group of people, about an employee specifically. In the middle of that spectrum, we talk about different treatment of similarly situated people. So, an example could be that at a company, male employees are given higher pay or better opportunities than their equally skilled female colleagues. Or Hispanic employees are assigned to lower level tasks or jobs than their similarly skilled and experienced non Hispanic coworkers. And then you get into the more subtle signs of discrimination, right? Disparate impact of a decision, policy, or a plan on a given group. A lot of times, disparate impact, especially, this is not an intentional form of discrimination, right? So, an example would be a disabled worker being terminated more frequently for violating the attendance policy than a non-disabled worker. So those of us in HR are always kind of looking for the cracks, right? Looking at policies to see, could they have a disparate impact, right? All right. I told you guys we would have some pop quizzes. So this is our first pop quiz. So we'll go through this scenario together, and then I'm going to ask you if you feel like this is discrimination. So you observe one of your direct reports, Dan, taking what you think is some kind of a medication. So days earlier, you and Dan had a discussion in which Dan disclosed that at least one of his family members suffers from heart disease and high blood pressure. You like Dan very much, and you're reluctant to assign him to a high pressure, although career enhancing project, which are concerned would jeopardize his health. It might just stress him out too much. So, can you choose to not assign Dan to the project based on what you know? So, I'm going to open up the poll, and remember that this is totally anonymous. I cannot see who answers what. We'll give everyone, about 60 seconds to answer. So, the question is, can you not assign Dan to the project based on what you know? So, you could either choose to not assign Dan to the project, or you cannot choose to not assign Dan to the project. It's a mouthful. So we'll give everyone a few more seconds to vote. Looks about half of you have put in your submission so far. So thank you so much for participating. Okay, just a couple more seconds. Go ahead and cast your votes. We're about 80% there. Okay, cool. So I'm going to end the poll and share the results. Hopefully everyone can see this on their screen. So 14% of you said, yeah, you could choose not to assign Dan to the project based on what you know. And 86% said you cannot choose to not assign Dan to the project. Yeah, and that's right, right? So you really have to focus on the facts here. So, what skills and strengths are needed to succeed in the role? Has Dan demonstrated those skills and strengths in his current role or in a prior position? Uh, gather concrete information needed to determine if Dan is qualified and appropriate for the job. Um, Dan possibly having high blood pressure can't factor in to that, right? Because that would be considered possibly a disability, right? And if we discriminate against Dan by saying, oh, no, man, you got high blood pressure, we can't give you this job, even if we're doing it for what we feel is his own good, Dan could come back and say that he felt discriminated against because of his disability status. So very good. Thank you all for participating. So we've talked about discrimination. Let's go ahead and move on to unlawful harassment. So unlawful harassment is defined as conduct that has the purpose or the effect of creating a hostile, intimidating, or offensive work environment. It has the purpose or effect of substantially and unreasonably interfering with an individual's work performance, or it otherwise adversely affects an individual's employment opportunities because of their membership in the protected class. That's the key, right? So some examples of harassing behaviors: slurs, that's very overt, right? Jokes, pranks, comments and innuendos, written or graphic materials. Somebody might have something that is considered offensive hanging up by their desk, right? Stereotyping, dead naming, that's a term where you call a transgendered individual by the wrong name, right? Misgendering somebody purposely, et cetera, et cetera. So here's a good question. We'll go ahead and do another pop quiz here. Must offensive conduct, those harassing behaviors, must those be specifically directed at the victim for it to constitute unlawful harassment? I'm going to go ahead and launch our poll. Let's do 30 seconds to vote this time, please. Must that conduct be specifically directed at the victim? Fast voting this time. Very good. We're about 3/4 of the way done. Thank you all for participating. I appreciate that. Okay, so we'll go ahead and end the poll and share our results. Yeah, and the answer is no. A victim does not have to be singled out or targeted by an alleged harasser. So claims may be based on conduct focused on another person, a group of people, or on no one in particular, right? So an employee could overhear jokes that are shared not even with them, or a comment that was, made to another employee, or see, a swimsuit calendar, for example, posted in somebody's cubicle, and they could feel victimized by that, right? They could feel like the work environment that has been turned hostile. So keep that in mind, guys, when you see or hear things that could be considered inappropriate to a reasonable person in the workplace. Anyone could say that they feel like they were a victim of unlawful harassment. So here's some examples of harassment cases where the employer was found to be at fault. So in the first example, back in 2005, a manager insisted on referring to the plaintiff, whose first name was Mamdouh, as Manny, despite repeated objections from the employee himself. He didn't want to be called Manny. The manager expressed the view that a Western name would increase chances for success and be more acceptable to clientele. Um, in the second case, a manager subjected an employee to religious lectures, made highly personal inquiries into her private life, told the plaintiff that she was leading a sinful life, right? So in the first case, you have a couple things going on here, right? So we have possible discrimination based on national origin. We have discrimination based on race, possibly religion, etc. So lots of things going on there, right? An employer cannot just change an employee's name because they don't think it's more palatable, right, to the clientele that they serve. In the second case here, this employee was subjected to proselytizing at work, right? Freedom of religion and freedom of, to not be harassed or discriminated against also extends to the freedom to not believe. Atheism is covered um, under religious freedom. So we've talked about harassment, discrimination. Let's talk about bullying, right? So workplace bullying was not necessarily a thing back in 1964 when these laws were created, right? But it is a growing concern in corporate America today, and the courts are beginning to view this as a form of harassment. So, in essence, workplace bullying is considered equal opportunity harassment, where the offensive and hostile work environment is created for everyone equally, right? So, workplace bullying is defined as a persistent pattern of mistreatment from others in the workplace that causes harm. It often involves an abuse or a misuse of power. That could be real power or perceived power, right? Bullying behavior creates feelings of I hate that word, defenselessness and injustice in the target. It undermines a person's right to dignity in the workplace, right? So, types of bullying behavior could be verbal, nonverbal, psychological, physical abuse, and humiliation. So let's talk about some examples of bullying behavior. Being treated differently than the rest of the work group, blame without factual justification, exclusion or social isolation at work, or the opposite, being shouted at, sworn at, being humiliated, um, pinpointed, right? Purposely withholding vital information from an employee that could make them fail. Excessive monitoring, micromanaging. And that doesn't mean that, as a manager, if you're a really involved manager, that does not mean that you're bullying your employees by managing them, right? But when it gets really excessive, that becomes the issue. So before we move on to our next pop quiz, I want to just again give a quick shout out to our Q&A session at the end of our call today. We've got a couple questions in there already. Just remember that your questions are totally anonymous. So if anything is sparking a question as we move along here, go ahead and put that in the Q&A session. Okay, so pop quiz. Is this workplace bullying or is it harassment? So, Frank, a manager, has a fiery temper. He shows frustration easily. He's quick to anger when tasks around the office are not completed according to Frank's timeline, right? Female employees in the office have been the target of his outbursts on several occasions, and he's even been known to throw objects toward a female when he becomes frustrated. Now, Frank's female employees maintain that he's never made a sexual or a gender related remark. He's never made any lewd comments, never referred to women in gender specific terms, never imposed gender specific requirements. So, what do we think here? Is this bullying or harassment? Again, I'm going to go ahead and launch our poll. Okay, we'll do about 30 seconds to vote. Bullying, harassment, or both? About half of you voted so far. Thank you so much. Give everyone about 10 more seconds to get your answers in. Okay, cool. So I'll end the poll. I'm going to share the results. Pretty mixed bag this time, right? So 38% of you felt like this is bullying behavior, 5% harassment, 57% said both. So what do we know here by what we've read in this scenario? So Frank does not sound like a fun guy to work with either way, right? This would probably be considered both, right? We don't have all of the facts yet, but it does have the purpose or effect to cause verbal and psychological abuse and humiliation, even physical abuse and humiliation if you throw something and it actually hits someone, right? But beyond bullying behavior, this may even rise to the level of unlawful harassment if Frank's behavior is consistently directed towards women, even though Frank is not making sexual or gender related remarks. You never refer to women in gender specific terms, etc. If he is always directing this behavior at the females, in the office, this could be considered unlawful harassment as well. It's pretty interesting. Hopefully, none of us ever has to work with a Frank, right? Okay. So that's kind of a nice segue into sexual harassment, right? So unlawful sexual harassment is defined as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. So, like we talked about earlier, there are two forms of sexual harassment. The first being quid pro quo, where submission to or rejection of that conduct is made a term or a condition of employment or is the basis for an employment decision. And this could be either explicitly or implicitly. Um, and then you have the hostile work environment. Um, I have in my 15 plus years of HR experience, I have rarely ever seen a quid pro quo case, right? Normally, what you see 99% of the time is that hostile work environment claim, right? Where the conduct has the purpose or the effect of unreasonably interfering with an individual's work performance, or it creates an intimidating, hostile, or offensive work environment. So we'll jump in a little deeper to hostile work environment and quid pro quo in a minute, but I wanted to talk a little bit about some statistics. So this is for fiscal year 2019 from the EEOC. In 2019, 7,514 sexual harassment charges were filed. Now, that was actually a decrease year over year from fiscal year 2018 by a little over 1%. That is an interesting number because we've seen a pretty steady increase up until last year. So things like the Me Too movement, right, and folks being really willing to kind of step up and speak out. We saw kind of a peak, right, in 2018, and we may see charges continue to decrease a bit now because people are more aware of their behavior in the workplace. That is at least what I hope is happening, right? Um, the 7,500 plus sexual harassment charges filed in 2019 made up a little over 10.3%, not a little, exactly 10.3% of all charges filed with the EEOC last year. $68.2 million were awarded, excluding monetary damages awarded in civil litigation, right? That's a big number, right? So the charge breakdown of those 7,500 plus charges that were filed, 16.8% were filed by men. And I think that makes a really good point that sexual harassment is an equal opportunity issue, right? So this could be male to female, it could be male to male, could be female to male, could be female to female, does not matter. Um, of those 7,500 charges filed, 4.5% were found to have reasonable cause. So it's a small fraction of those charges that were actually found to have reasonable cause. But it's still important to note that 7,500 charges, those people all felt like there was reasonable cause. So more than likely, enough was not done in their workplace to make them feel comfortable and supported, right? 54.6% were found to have no reasonable cause, and then 8.8% were settled before it even, made it to litigation, right? So some interesting numbers. So quid pro quo, this is kind of the big nasty sexual harassment scenario that we see in the movies that we remember from, the Clarence Thomas situation back in the day. Well, some of us, I might have just aged myself there. They're generally very black and white, right? It literally means this for that. So there's some obvious examples of quid pro quo, right? Aside from what we've seen in the media lately, quid pro quo cases, they're really rare, but it's I'll give you that great assignment if you go out to dinner with me. Yeah, I transferred that file to someone else after you told me you were uncomfortable with my flirting because I wouldn't want you to feel uncomfortable. Have dinner with me and we'll discuss your prospects for promotion. These could all be examples of a quid pro quo case waiting to happen. So more often, the hostile work environment claims are what we see in the workplace, right? A hostile work environment is defined as a highly charged sexual work environment. So here are some examples. Unwanted sexual advances, whether they involve physical touching or not. Sexual jokes, references to sexual conduct, gossip regarding one's sex life, comments about a person's body, their looks, etc. Displaying sexually suggestive objects, pictures, cartoon. We talked about a swimsuit calendar as an example, right? Unwelcome leering, whistling, brushing up against someone, asking someone about their sexual experiences, discussing your own sexual experiences, etc. So, in order for behavior to rise to the level of illegality, it must be unwelcome, severe, or pervasive, right? There's a scenario in which two coworkers may comfortably engage in these behaviors in the workplace, but it's important to remember that, employees do not have to complain for the conduct to be deemed unwelcome. An employee may appear to be okay with the conduct, but later claim that it was unwelcome. An employee might even participate in the conduct in the beginning, right? You've got a banter, there's some flirting, or you have coworkers or a manager and an employee that are dating, or having some kind of romantic relationship. Um, but one of those people could later say that they felt coerced, or they felt like they had to, or that somebody just took it too far, right? The banter went too far, etc. Um, so the conduct has to be unwelcome, and it also has to be severe or pervasive. So some factors to consider is, was the conduct physical or was it verbal? How often has it happened? Um, so if it's just one comment one time, do we consider that to be severe or pervasive? Wouldn't be pervasive, could be severe depending on the comment, right? Is it blatantly offensive? Would a reasonable person find that conduct offensive? Uh, was the conduct done by a coworker or a supervisor, a person in a perceived position of power or control over that individual? Was the conduct done by more than one person? Does it seem to be condoned by management or ignored by management? Was it directed at more than one person, like Frank throwing things and yelling at the females in the office, right? So, sexual harassment can occur both inside and outside of the workplace. It's not only applicable in the building during business hours, right? So, if you're attending conferences, offsite company parties, etc., the same standards apply, right? Anytime you're interacting with your coworkers. So, it's best practice to assume that you are on duty anytime you're interacting with coworkers, including through social media, right? So additionally, you should not be subjected to these behaviors from other non-employees, right? So vendors, suppliers that your company works with, contract employees, etc., um, shouldn't be subjected to this behavior and should not subject you to this behavior either, right? We would want you to respond to inappropriate conduct from a non-employee in the same manner as you would if you were an employee. So we do recognize that most of the time harassment, especially a hostile work environment, is unintended, right? But when investigating a claim, we consider the impact of the behaviors, not the intention of the behaviors. So with that in mind, excuses like these shown won't change the nature of the allegation or the outcome of an investigation. So as a best practice, first consider what the impact of your behaviors might be on others. Pop quiz time. So is this sexual harassment? Bob and Karen, they've worked together for many years. Bob has always referred to Karen as my girl, and he often puts his arm around her when he's talking to her. Karen doesn't like it, but she puts up with it. So, what do we think? Is this sexual harassment? Let's go ahead and launch our poll. 30 seconds. Pretty simple answers this time. Yes or no? Oh, the votes are coming in fast. We'll give everyone another, 15 seconds or so. Okay. Looks like most of you have voted. Go ahead and close this polling and share our results. Yeah, that was kind of a gimme, right? We are all in 100% agreement that that is sexual harassment. And it really, Bob's conduct may absolutely constitute sexual harassment. It's unwelcome and it's of a sexual nature, right? He's not asking her out, he's not overtly flirting with her, but he is doing things that are related to her gender, right? He calls her my girl. He wouldn't call a male coworker my girl. He puts his arm around her when he's talking to her. He may not do that with a male coworker, right? We don't know that, but he's doing things that make her uncomfortable. So Karen should let her objections be known by either telling Bob or reporting her concerns to her supervisor. If Bob's actions continue at that point, it could be considered sexual harassment. So, food for thought here, and we don't have a poll on this, but consider, what if you're Karen's coworker and you observe this happening, or you're Karen's manager or your Bob's manager? How would that make you feel? And think about what action you might take. And again, we don't have a poll on that, but just some food for thought. Double pop quiz. So you're in the break room with two coworkers of the same gender. One employee makes a few jokes of a sexual nature, and the other coworker remains quiet, doesn't say anything. So let's go ahead and open our poll. Could this be considered sexual harassment? And again, the answers are coming in really quickly. So we'll give it another 15 seconds or so. Oh, looks like we don't even need to. You guys are decided. Yeah, for sure, right? This may also constitute sexual harassment due to a hostile work environment. So one of the coworkers might be super offended by the jokes that are of a sexual nature. Doesn't matter that they're all the same gender, right? If the employee is offended, they really should let their objection be known. But there's a few ways that you can do that, right? You could tell the coworker or report concerns to HR or a supervisor. And again, if these actions continue, it could be sexual harassment. So, another quick legal review. An example of a harassment case where the employer was found at fault. This one is particularly egregious. Alford versus Aaron Rentz in 2011. This was the largest individual sexual harassment jury verdict awarded outside of the state of California, right? So the basics: a 20-year-old rental store clerk alleged that there was a pattern of harassment initiated by her supervisor. Started out with him using degrading pet names, honey, sweetie, and ultimately it kept going and ended up in the sexual assault of this rental store clerk by her manager. So the plaintiff, the clerk, called the internal harassment hotline, called HR, right? But the complaint was never properly followed up. So whoever received that complaint either didn't take it seriously, forgot to pass it on. Nothing ever came of it. And it got worse and worse until she was actually sexually assaulted. So the harasser's supervisor also confronted the plaintiff about the complaint in front of the harasser, telling him to watch his back. This whole situation was a mess, could have been stopped very quickly. The verdict, $95 million. That's a lot. That'll shut a company down, right? So this is how a simple hostile work environment situation can go really, really wrong. It's important to note with this legal review, I think it really, that $95 million verdict, yes, the behavior was super egregious, right? But courts often will focus on the company, how the company reacted, right? Or their failure to react and act on a sexual harassment claim. And this $95 million verdict absolutely shows that the court held the company responsible for not keeping their employees safe. So let's talk about retaliation. So the law defines retaliation as taking an adverse employment action against an employee who engages in protected activity. So protected activity could be making a good faith complaint of harassment, discrimination, bullying, helping someone else to complain, providing information regarding a complaint is being part of an investigation. Um, Federal law prohibits retaliation against somebody who engages in one of those protected activities. So, examples could be discipline, reprisal, intimidation, employment decisions that affect the employee's conditions of employment. So, let's look at a scenario and we'll decide if we think that this is retaliation. So Erica is interviewed as part of an investigation into alleged sexual harassment by her boss, Dave, of another employee. So Erica is not the person who feels like they have been harassed, but she participated in the investigation. Dave then asks Erica what she said about him in the interview. Erica declines to say anything, citing the company's confidentiality policy. Dave comments to a group of employees with Erica present that he suspects that Erica did not help him in her interview. So, some things happen in the following weeks. Erica's vacation time request is misplaced and then lost. Um, Dave gives Erica her scheduled performance review, raises several legitimate performance problems that he has not previously discussed with her. So, what do we think? Is this retaliation? And this is our last pop quiz. So, pretty simple, yes or no. What do we think? The votes are coming in pretty quick. So we'll give it about, 5 more seconds or so. Okay. So I'll share our results. Yeah, 95% of you say yes, 5% say no. So let's talk about this. We definitely know that Dave's comment to the group and question to Erica, it was very inappropriate and should have been reported right away, right? Erica really should have said something. But again, even if she doesn't, that doesn't, protect Dave. The timing of the lost vacation request and the performance review being rather negative give the appearance of retaliation. But we would want to investigate further to get all the facts. But here's the thing, Dave's comment um, to about Erica in front of her, and Dave even asking Erica what she said in the interview, set this all up, right? So now anything that he does is going to be viewed under a different lens, right? He could have legitimately lost her time off request. She had performance issues that needed to be addressed. But now the negative performance review is going to be seen in a different light. And really, honestly, performance review is not the time to surprise people. They should know, right, that they're failing in some way prior to that review. But that's a whole nother training. So thank you. We'll move on from there. Thanks for taking the quiz. So we've talked about a bunch of definitions. Now let's talk about how do we respond. So first and foremost, how do you respond when you're the recipient of an unwanted action, right? Whether you feel like you've been discriminated against, harassed, bullied. Should you feel comfortable with a coworker, we encourage you to first attempt to resolve the issue with the other person to the extent that you feel like you can. So confronting the harasser is not required, but it might be an effective way to stop unwelcoming behavior while preserving the working relationship. If you're not comfortable with this approach, though, you should really start at step 2. When you're confronting the other party, inform them that their behavior is uncomfortable. Ask them to stop immediately, right? John, your jokes make me uncomfortable, and I appreciate it if you could please stop. Short and sweet. We encourage you to keep documentation of all incidents, including witnesses, the date, time, location, and how you responded. Should the behavior persist, this information will really be helpful in our investigation. So step 2 or step 1, if you don't feel comfortable confronting the person yourself, you want to report that behavior immediately. Go to your direct manager, any member of management, with whom you're most comfortable, um, and then escalate to HR. Uh, Step three, cooperate with the investigation that follows, right? You want to immediately report any continued unwanted behaviors. Um, and, if you feel like you're still experiencing retaliation or intimidation, right, from assisting in an investigation. So, our commitment to you, right, is to quickly and thoroughly investigate the complaint, maintain confidentiality, and protect anonymity to the extent possible. We want to help reach a timely decision on the alleged behavior, attempt to resolve the issue with each party if applicable, take appropriate action in accordance with company policy, and monitor to prohibit retaliation. So, how do you respond if you're the recipient of a complaint as a manager, right? Somebody may very well come to you to make a complaint. So, what to do? These are things that you really should do. Actively listen, right? I hear what you're saying. I understand. Parrot things back to them, right? What I hear you saying is blank. Is that correct? Right? Use nonverbal cues such as nodding, eye contact, leaning forward. We're not writing emails, checking our phone when these conversations are happening. We are focused in on the employee. Take ownership of your actions and your behaviors. Be open to solutions. Assure the other person that you will take action to resolve the issue, and then maintain confidentiality. So if you have been given feedback, or a complaint is brought to you, it's really important that you limit the amount of people that hear that. Right? It really should be HR, concurrent HRO, your direct supervisor if it's appropriate, and that's it. Right? So here's some things that we would ask you not to do when a concern is brought to you. Don't disregard the employee's feelings, even if you think their complaint sounds ridiculous, right? Even if you don't agree that they've been harassed, don't tell them that, right? Don't avoid or ignore the issue. We all have a duty to act and respond when we have situations like this arise. Don't allow emotions to take over the conversation. Don't impose personal values or beliefs. Don't interrupt the person. Again, with the confidentiality, don't share the situation with other people. Talk disparagingly about the other person. If somebody comes and says, Bob is making jokes in the break room again. Oh yeah, Bob's a jerk, right? That would be a misstep on our part, right? And don't treat the complainant differently after they've complained, right? So let's wrap up our session talking about management responsibilities. And again, if any of this is sparking any questions for you, put them in the Q&A tool and we'll get to them at the end of the session. So, excuse me, what does all this mean for our company, right? Risks of a claim are real, particularly in today's climate, right? Costs of a claim are high. The cost is not just financial, it could be your reputation in the communities that you work in and serve. Claims typically focus on managerial action or inaction. Failure to respond appropriately is often viewed as the real wrongdoing, and is most severely punished by judges and juries. So what does this mean for you as a manager? Again, I'm not trying to scare you here, right? But all managers should keep a discussion log, right? That documents the day and the summary of conversations like this. It's important to keep your documentation just to the facts, not your opinions, judgments, assumptions, Bob's a jerk, etc. Right? Be sure to capture both what you shared in the meeting and how the employee responded, both verbally and non-verbally. Were they crying? Were they nervous? Did it seem to really affect them, etc.? These are all really important things. Keep in mind when you are creating documentation, um, all of this is discoverable in a legal case. So that's why it's really important that we keep it just to the facts, not opinions, judgments, etc. So, duty to act. I've said it several times. Knowledge triggers a duty to act. So, in the eyes of the law, anything a manager does or doesn't do is a reflection of the company's action or inaction. So your actions are a factor in a legal case. Whether you see it, you hear it, or just hear about it, it's important that you report anything that might be in violation of company policy so that we can then follow our internal procedures. So, knowledge on your behalf um, triggers the immediate non discretionary obligation to report it, investigate it, whether that's your role to investigate or you help with the investigation, take appropriate corrective action, and prevent future violations. So, if you receive a complaint, what should you say? Hey, thanks for coming to see me. We take these types of complaints really seriously. We'll immediately look into this. We'll get back to you right away. In the meantime, please maintain confidentiality. We'll commit to doing the same on our end. Um, just collect the facts, remain impartial, seek only to uncover the facts of the case. Make sure you take every concern seriously and always reassure the employee that we'll look into this as soon as possible. Then immediately report the allegation to HR and to management. Couple other things that we would ask you to do: determine if the employee has approached the other employee, right? Or if they would be willing to do so. Thoroughly document the conversation, like we talked about: times, dates, actions. Involve HR, involve concurrent HRO. Launch the investigative process immediately if that's appropriate for your position, or if HR asks you to be a part of that. Maintain the confidentiality. Monitor the work environment to make sure that retaliation isn't occurring. So these are the most common mistakes made when handling a complaint. An inappropriate initial response, right? Expressing opinions, discouraging the complainant by, verbal or nonverbal conduct, right? Rolling your eyes or saying, oh, yeah, do you really want to move forward with this? Those would be completely inappropriate initially. Prejudging the claim or defending the harasser. Oh, Dan would never act like that, right? Second mistake managers make is not registering the comments as a complaint. An employee does not have to come to you and say, I would like to make an official complaint. An employee could make a comment about feeling uncomfortable or about, gosh, I wish that Dan would stop saying things like that. That is a complaint. Recognize it for what it is. Third mistake, not taking complaints seriously because the complainant is a poor performer, maybe just a contract worker or a vendor, or for some reason in your mind lacks credibility. Don't allow the complainant to control the process, right? Somebody could come really upset and they want action now and you need to fire this person, or, the complainant is not in control of how we handle the situation, how we handle the investigation and the action that we take. Um, and then number 5, not knowing or following company policy. Take a look at your handbook. Take a look at your, policy. How should you be reporting this information? Who do you need to go to? Look at your anti-discrimination and harassment policies. Know them and understand them because you're responsible for following those and modeling those behaviors. So after all that, let's talk about how you can contribute to a positive working environment, right? We're guided by our core values. These should serve as your North Star for all workplace interactions, both internally and externally. So Roy Disney says it's not hard to make decisions when you know what your values are. So some key takeaways: be thoughtful about your interactions. Consider these questions. Could this be perceived as offensive to others? Is this in line with company values? Will it help create a working environment that allows the organization to succeed over the long term? Cultivate a work environment where people are treated with respect at all times. Avoid behaviors that could lead to real or perceived harassment, sexual harassment, discrimination, or bullying, and reinforce positive workplace interactions and quickly address negative behaviors. So, as a manager and a leader, do your part to create a positive, safe, and comfortable working environment for your employees. Um, Understand and comply with company policy. Err on the side of addressing an incident, even if no one formally complains. and maintain confidentiality of claims. Closely monitor the work environment to prevent retaliation. Okay, so let's go ahead. I'll start my webcam back up here. And I would love to go through our Q&A. We have a few questions here. Um, so first question, can you tell us what defines persistent? So when we're talking about a work environment being, hostile because it's severe or pervasive, I believe that's probably where this question came in. So if we have, um, you know, behavior persistently happening all the time, or more than once, pretty frequently, that would be considered persistent, right? I don't think there's a definition as far as the law is concerned of how many times a behavior can occur, etc. Just know that the more often a behavior happens, if it happens more than once, right? The joke keeps getting told, the poster keeps, hanging in the break room or whatever the case is, the more severe and pervasive and persistent it is. And I hope that answered your question. So another question, sexual harassment. What actions for the manager are appropriate besides keeping the record of it to correct the situation? In other words, is it okay for the manager to talk or take any other actions towards the employee who's the source of harassment, or the manager can't do anything before the investigation is done? Also, what if the employee feels harassed by a customer? What can a manager do about that? Okay, so I'm going to take those two questions separately. As far as the manager's behavior before the investigation is done, that's a really good question, right? I think first and foremost, when HR gets involved, right, and we're helping to lead that investigation, one of the first conversations we're having is with the alleged harasser, right? We're putting that person on notice in that conversation. It's not just fact finding. We're also not condemning that person, right? But we are saying, hey, if you are saying this, if you are, doing these things, it's time to stop, right? So that person is on notice already that, there's an investigation happening, that, somebody's uncomfortable with something that they said or that they did. So it would be like one of our scenarios where Dave asked Erica what she said in her investigative conversation and then made comments about how she probably didn't help them, right? That behavior is seen as retaliation. So part of our conversation with the alleged harasser is going to be, here's some things we would ask you not to do, right? We would ask you to make sure that you're not behaving in a way that could be perceived as retaliatory. Don't go talk to the person that has made the claim, etc. So a manager's job while that investigation is ongoing is to watch for the retaliation, right? Or watch for continued harassment. Really, really great question. And then if an employee feels harassed by a customer, we are under the same legal and honestly ethical and moral obligation to protect our employees from a customer as we are from an employee, a vendor, a contract worker, etc. So if a customer is harassing one of our employees or an employee brings a complaint like that to us, we're investigating, right? We may respond differently. You can't fire a customer, right? But you can ask a customer not to return. So the response may be a little bit different, but our actions internally aren't or should not be. Great questions. Okay, let's see. So I have an employee who's experiencing unlawful harassment, nothing directed towards her, but jokes, comments, slurs made out loud in the office space by one of her coworkers. She brings the issue up with me, her manager, but she doesn't want to bring anything up with anyone else because she doesn't want to deal with retaliation. She works in a different office, and I don't have any authority to change the office culture. It's run by a different entity. I want to respect her decision, not to say anything, but worry about where it puts my organization. Current status is I've had her start documenting the instances. Okay, good first step. Second step is you as a manager, even if you're not that person's manager, have a duty to act. if an employee comes to you and says, I need to make a complaint, I need to tell you this thing, but you can't tell anyone, um, good rule of thumb, never promise that. And I, in all my years in HR, especially, I've had people say that to me several times. I got to tell you this, but I don't want you to tell anyone else. I will never promise that. I will say, hey, you know what? I'm bound by a responsibility to protect you. And so it really is going to depend on what you have to say to me. I have never had someone back out of that conversation at that point. I've never had someone say, oh, never mind, I'm not going to tell you. They're coming to you because ultimately they know something needs to be done about it. So in this particular situation, you can't sit on it. You got to let the employee know that you have to make a move, that you have to go to HR, go to your manager, and let them start the investigation. Okay. Is political affiliation a protected status? For example, if an employee posts an opinion on Facebook and the employer sees the post, can it be used against that employee? That is a slippery slope, my friend. Um, Political affiliation is not protected. However, we are all protected by freedom of speech, right? So if that employee is on their own social media, and not representing the company in any way or posting that on the company's social media platforms, etc., um, employers don't we cannot ask them to stop, because they have the right to say those things. Um, you know, uh, as far as um, if they were acting in a way that they were tied to the company, that's a little bit different, right? So um, if they were on their page, Liza Town, and I am employed by ABC company, and that was easily visible, and now I'm out posting hate speech, or I'm out posting political opinions that my company might not view as appropriate. My company can then say, hey, please remove your employment status from being visible on your page because it's being tied back to you. So I hope that makes sense. That was a bit of a long answer to a short question. Why is training so important? How do employee and manager trainings such as these help employers with liability and future claims? Yeah, really, really good point to make. I love doing these trainings, and I'm a bit of an employment law nerd, so that's not surprising. However, I think that the main reason that training is important is not just checking the box. Okay, you've had your harassment training for the year. It is really arming you with the knowledge of what's appropriate and what isn't, right? That really helps with liability and future claims. Um, we're hoping that by having these frank conversations with you as managers, you can understand what to look for, what to pinpoint, right? And also how to respond so that you don't become, part of the liability, right, for the company. Okay, great. Let's see. I want to make sure I didn't miss anything. So we had two questions about Facebook posting that are pretty similar. So I kind of hopefully answered those in one fell swoop. And I think we got through all of our questions. Let me check our chat here. Yeah. So one thing, Laura, the Q&A question, your name was showing to everyone when you asked the question. With the Q&A, you do have to check the little box to say that you want your question to remain anonymous. So I'm sorry if I went through that too quickly at the beginning of the session. I do apologize. Yeah. So any other questions for our Q&A session? All right, I think we're good to go. Thank you for interacting. I know that was a lot of polls, but I really appreciate everyone attending, interacting. Please do reach out if you have any questions in the future. We're here for you. Okay, and everyone have a good rest of your day. Take care.